Welcome to this wonderful event. Music Portland is proud to host Rational Unicorn Legal Services in Legal Bandcamp 101. Because as we all have come to understand, the way that music and our musical creations are monetized and our businesses are protected seems to be changing all the time. It's absolutely important that you keep in touch with these issues and stay up to date. I'm going to do a quick intro for Music Portland so that those of you that are unfamiliar with us have some sense. We are a grassroots local nonprofit organization that has two sides. One is it supports the business of music. None of you listening are hobbyists. You are doing this as ideally a career and where you make some or all of your income. And Portland has never had to work very hard to be a place where music can thrive. But as it's grown, it's making it increasingly difficult for music people to be successful. So Music Portland focuses on the business aspects, how to make businesses, musicians, music entrepreneurs successful in this community. So you don't have to move away to be successful. The other side of our nonprofit is focusing on the social justice, equity, and cultural empowerment issues. So that's things like our Leadership Equity Advocacy Project, that is a BIPOC-led initiative to really define what this city needs to do for the BIPOC music community that's been so disadvantaged by the way that things have evolved organically. We can do way better. The other things that we're doing on that side, looking at the art and culture of music, is artist grants, developing funding for artist grants specific to popular independent music. We're also looking at creating a Portland music history and supporting BIPOC entrepreneurs that are interested in starting businesses. So we're doing both sides of the stick. The Legal Bandcamp, I think, falls squarely into the being successful as a business. Some of the other things that Music Portland has been working on, because everything that we do is powered by our membership. All that you need to do at a minimum to be a member is to raise your hand, fill out about a 2-minute profile, and let us know that you're here. It is the only way in Portland to acknowledge yourself as a music professional, whether you make $500 a year performing or you make hundreds of thousands of dollars running a music business. We need to know everybody that's in this economy. We need to know employees of businesses. We need to know artists. We need to know people. By doing that, it allows us to represent the industry more completely and more convincingly, to raise money to support grant making, to communicate the potency and breadth and scope of our industry to policymakers, and all of those other things. So the things that we're pushing for are expanding the film office to include music. We are lobbying hard to change the way that noise management is handled and how sound and music is managed within that, because right now it's the tip of the spear for over enforcement and some pretty biased, prejudicial approaches to people of color in our music ecology. We're working with the OLCC, who for the first time is opening up their permitting and prohibited use doctrines for the first time in 30 years. If we don't stand together and make a point of what we as a music community need, then they'll finish it, close it up for another decade or two. It's about standing together and making our voices heard. We're also creating this industry directory. If you are a music business, we're not currently listing artists, but if you are a music business of any kind, by creating a profile, you get a free basic listing. We also encourage people to support our work, $25 a year for an individual or $3 a month, or $250 a year for a business. The business gets a whole list of additional benefits. musicportland.org/join is where you go to find out what you get for each of those levels, why it benefits you. And we strongly encourage you to support our work. Again, making a profile is step one. It allows us to say, this is our community. Step two is to kick in a little bit that your means allow. The other thing is for businesses, if you join up as a business member in the month of February, you save $100. It is $150 instead of $250 for the entire year, which gets you a multimedia premium listing in our music, in our industry directory, and a bunch of other great things. So do keep us in mind. We work hard for you every day regardless, but if you have the means, this small amount, please do consider becoming a paid member at an individual or business level. Enough about us. Let's talk about our amazing speakers. Michael Jonas and Nicole Hetz are from Rational Unicorn, and I'm going to let Michael start off and kind of introduce the firm and the kind of unique role that I think they're playing in our city. So take it away, Michael.
First of all, thank you for having me. Hopefully you all can hear me okay. I tried to change some sound settings, so I think that worked. My name is Michael Jonas. I am the principal attorney and the owner of Rational Unicorn Legal Services. We do community business law. So our clients are small businesses, nonprofits, and artists and entertainers. We have clients in the music industry of every type. So we have clients who write music, who license it for movies and other projects. We have musician clients. It kind of runs the gamut. You know, wedding industry folks, DJs, sound mixers. We have a client who has a recording studio. So it's a pretty wide range. What I want to tell you is that we really are here because we care about you, we care about your business, and we know that there's not just the creative component, there is the protective component, right? So there is how do I not only create, how do I protect what I have created? How do I share it with the world? And how do I profit from it in a way that's fair and just? So that I have the way, you know, I can negotiate, I can make sure that I'm out there just like any other business, because that's what you should be doing. I'll stop rambling. It's been a really long day and a long week, but I'm very excited to be here. This is one of the things that I was looking forward to this week. One of our attorneys, Nicole Hetz, she's going to be speaking first, kind of giving you an overview of IP law, business law. And then I'm going to speak after. I'm going to talk specifically about contracts that you should know about for the music and entertainment business. So Nicole, take it away.
All right. Hello, everyone. My name is Nicole Hetz. I'm one of the attorneys for Rational Unicorn. My pronouns are she, her. I'm happy to be here on this snowy day. So let's get started. Let's start talking about music and business. So in order to protect their personal assets, musicians typically create a business entity such as a corporation or a limited liability company, an LLC. These limited liability entities shield the owner from personal liability for any claims arising from any contracts or other arrangements entered into on behalf of the individual through the LLC or entity. So while shielding an individual from personal liability is one of the most important advantages of creating this corporate entity, there are also several other important benefits for an artist's career. One of them is having a separate corporate entity that permits the musician to open a bank account in an assumed name. So this also facilitates easier tracking of your expenses, and when you're at the moment of writing off your expenses, the ones that you have properly documented. So in order to determine a corporate entity's eligibility for these deductions and not have the IRS categorize your musical career as a hobby, the entity must substantiate that they're actually carrying on the business activity for profit or to attempt to make a profit. So since most artists do not typically make a profit and end up incurring losses for great spans of time, they may be permitted to deduct this documented losses on their tax returns. So some of the factors the IRS may consider in determining whether or not you are a for-profit business and thus eligible for appropriate tax deductions are whether you carry on the activity in a business-like manner, an examination of the time and effort you're putting into this activity, whether you depend on income from the activity for your sole livelihood, whether your losses are due to circumstances beyond your control, and whether you change any of your methods of operation in an attempt to improve profitability. So I form my business entity, now what? Another benefit is that a corporate entity typically is governed by a written contract. It's either an operating agreement for an LLC or a shareholder agreement for a corporation. So that outlines how the entity will operate. This includes an outline of how the profit and losses will be distributed. Also, it specifies how any management decision should be addressed and how additional owners and members can be added or removed from the entity. These companies also provide easy management over any artist's own intellectual property, like photographs, logos, sound recordings for licensing and distribution purposes, as well as any tangible property like instruments or mixers. Without this outlined procedures, it may be very difficult to make certain career decisions. So while these entities provide numerous benefits to the owners, there are potential ways a third party can do what is called pierce the corporate veil. So that is an attempt to attach the individual personal assets and disregard the existence of that corporate entity to protect the owners. Thus, it is essential that the company follows any and all statutory procedures and guidelines, which are different in every state. It is vital that the entity it is utilized for a proper purpose and not just merely as a shield from personal liability. Some of these corporate formalities include the preparation of an annual corporate minutes to ensure the corporation is a real functioning entity. Also, careful use of your business bank account, as well as the separation from your personal accounts. So some labels may even require the creation of this corporate entity to permit accounting and payment by utilizing the entity's tax ID or EIN, which is the employer identification number similar to a company's social security number. Next slide. So here we go. Tips for a successful start. Let me name just a few that you need to take into account. So first, there's no real bright line rule about what you need to do, but these are our recommendations. The first thing, always do a trademark search prior to selecting a company or entertainment name and have a qualified attorney to do so. This is why. An artist should ensure that the name and corresponding social media and website domains are available prior to creating and marketing works under a particular name. The worst situation is building a following with a certain name to only receive a cease and desist letter from another similarly named artist demanding that an artist stop utilizing this name. Second, if you're in a band or in a group, make sure you have a signed band agreement that details the members' rights and responsibilities. Band members should resolve to ensure that all applicable band members' matters and procedures are discussed and agreed to in writing, signed by all the members. This is necessary to avoid any misunderstandings. This document should list the proper mechanisms to ensure the continued profitability of a band, especially if certain internal situations or relationships begin to deteriorate. Third, if you have a manager, make sure you have a signed agreement with them. In most situations, an artist's first manager, or sometimes only manager, is their friend, their family member, or significant other. So while familiarity and trust may exist in these relationships, when money, and in particular substantial amounts of money, are involved, it is prudent to have a signed agreement. That document will outline who is entitled to what and under what circumstances. Since this is business, it is vital that all the parties understand the nature of the relationship and that all the parties are adequately protected. Finally, one last tip is if you're working on a recording with a producer or a performer that isn't you, then you need an agreement with that person to clarify who owns that recording. An artist should always remember that if a contribution isn't theirs, then the artist cannot use it unless they have the rights from the creator to utilize it. This applies to any beat, vocals, or other material that the artist didn't personally perform and is included in the final sound recording. So along the lines of intellectual property, I want to talk about a little bit about copyright. So for a work to be copyrightable, it must be original and fixed in a tangible form, such as a sound recording fixed on a CD, MP3, or other digital sound recording file formats. Some examples of copyrightable material that are common in a musician's career are the actual song recordings, the lyrics, the underlying musical composition, music videos, or other audiovisual works like photographs, logos, or other visual materials, even autobiographies, websites, any other unique textual information that the artist creates. So the same party or several parties may own rights in each of these distinct copyrights for the same music. Each copyrights conferred each owner with several exclusive rights. This includes the exclusive right to reproduce the work, including the mechanical reproduction of a musical composition in CDs, downloads, and vinyls, as well as authorized third parties to do the same. It includes the exclusive right to distribute the work through Spotify, Pandora, YouTube, to prepare different types of work with the original work, like a spin-off, or to publicly perform the work like in a concert. So a copyright generally provides the owner with the exclusive right to publicly distribute copies of their work by sale, rental, or lease, and to publicly perform or display the work, such as selling copies of their CDs or publicly performing at a restaurant or a nightclub. So in the music business, the songwriter and composer typically assign their copyright and their underlying musical composition to a publishing company in exchange for receiving songwriting royalties. Additionally, the copyright in the sound recording is generally assigned to a record label in exchange for receiving royalties for the sale and licensing of the sound recording. The recording copyright may be owned by the label and may be considered work for hire. Included in this assignment may be a mechanical license, which authorizes the label to mechanically reproduce the underlying musical composition on phonograms or other sound carriers such as downloads. So the main lesson with the copyright is always register your copyright in a work with the US Copyright Office, because the failure to register a copyright will prevent the recovery of certain damages for infringement, including attorney's fees. So now with Michael, I will let you take it away with the types of contracts.
Thank you, Nicole. That was wonderful. I want you to know, first of all, that I know that when you're creative, you often think that things just happen, right? Like we're just riffing, we're making music. All of these things, all these legal things, they seem like they are about the government and the man, and they're taking away from our creativity. So I get all that. I want you to know that I understand that. So that said, it's sort of this quote, which is structure sets you free. So if we can get these things prepared for you with preventative business law prior, you can do more creative things because you're not worried about it. So you only form your entity once, or your band partnership agreement once. You only, form some of these contracts once. So as long as we're getting them in order, we're not worrying about this every single day. So if you can tell yourself that this is a career or a job, well, how would I treat it as such? I would have formality to it, right? So we're going to talk about contracts. So these are the contracts that we need to talk about. Split sheets, producer agreements, contractor agreements, partnership, operating agreements, agreement with bars, artist agreement, recording contract. The thing you need to know is these are all arbitrary names. You can have any contract with any private person, right? Your contract could be that you're going to play at someone's venue and babysit their child, and you're going to be on one of their recordings for their album. We can make any contract as long as it's legal. So keep in mind that the best thing to do is to look at the relationships that you have and the agreements that you have and figure out how they can become legally binding enforceable contracts. So the first one is split sheets or producer agreements. Two separate things, but sometimes seen as one if the producer agreement is, really small, really not formal. So what we're going to do with these is we're going to set forth who owns what on the track. So what I like to tell music clients is having a template split sheet with you wherever you go is always the best thing. Because what happens is you're in a studio and someone says, oh, I want you to use this beat. Oh, don't worry about my ownership. I'm not going to come after you. Little do you know, that's the same person that then says that they own the song when you're putting the song out. So if you can, wherever you are, before you're recording something, if you can get the person to agree on a piece of paper, a split sheet's very informal, but a breakdown of what they're doing and what their ownership is, or maybe what they're writing down is that they release themselves from the ownership. So you have them sign off that they're not going to argue ownership later on. So what we have is we walk away from a recording session and we have a mini contract that has legally enforceable language, and it's all on one sheet of paper that was something you kept in your backpack. So that's something we can do is we can keep split sheets with us no matter where we are, wherever we go. And let's see, I mean, I've pretty much talked about that, but the thing I want you to know is there's this sort of like, well, if I give you a contract, you're going to say to me, well, I can't be creative to you, or it's too formal for me. So if your music or your art is your business, and I talk about this a lot, your art being your business, that's the formality that you have to take. So you have to make the decision today, is my music my business? And if my music is my business, then I'm going to have a business entity and I am going to have contracts. If your music's not your business and it is a hobby, then that's fine. Then Nicole and I don't care about the formality as much. So that's a big part of this is you sort of drawing a line in the sand and saying like, okay, I'm serious about my music as a business, so I'm going to do these formalities. Next slide, Nicole. So the next one is contractor agreements. So, we have the split sheet stuff, but what if you want to hire someone to play the drums, on your song? What if you have a saxophonist? You're like, it'd be really great if there was a saxophone in the song. Okay, well, what rights do they have? Nicole mentioned work for hire. Is it that you're going to pay them for their saxophone performance in your song and that's it? The work for hire, you're keeping it. They're not going to get any rights. Or is the expectation from them that their name is going to be in the copyright that's registered and they're going to be getting royalties? And every time you perform the song, you're going to mention them, or they're going to be on your CD. We need to have a contractor agreement with the people who are performing with us that are not part of our band, And that's not necessarily like a musician. It could be someone who is a contractor for the soundboard. It could be someone who is helping you with your process. Someone creating graphic design for your CD album artwork. Do you own the artwork that they created, even though it's your band logo? So those are sort of the things that we have to capture in these contractor agreements. The other thing is you are a contractor as well. So you should start thinking about when I'm doing things, do I need to give this person a contractor agreement? Okay. Next slide. So the other one is partnership operating agreements. Nicole talked about this. What is a band? A band is a partnership. Like, I don't care, again, there's a creative component, but if you're in this for a business perspective, this is your future. Music is your career. I actually have a client who I've talked to several times about this, who is in several bands, and he's sort of like, I don't know if they're serious. I don't know if they want to do this as a career. I go, this is a really good test. So if they're willing to sign a partnership operating agreement where you all agree on ownership and who owns the music, how do we add a bandmate? How do we get rid of a bandmate? What happens when we tour? If the people that are involved with your band don't want to do that, then they're not serious about having a career, right? The other question is, if they're not willing to do a partnership operating agreement with you, how are they going to ever sign with the record label with you? How are they going to ever do any sort of distribution or royalty agreement? They're not, because they're not in that sort of career mindset. So if you don't yet have this, I would encourage you do this, not only for the protection, but for the process of it, that the process in itself will tell you who is serious and who's not serious. It's really important to think of your band as a business partner, right? Because if you think about it, they are a business partner. So who is profiting from this? Here's another thing you can put in a partnership operating agreement. Nobody's going to take money out of this pot that we've earned until we reach this amount of money. So if we perform and we do really well, and one of your bandmates is like, well, I'm going to use this for this amount of money to book us a trip or to do it, like, no, that could be in the partnership operating agreement. They have to have unanimous consent by all the partners to do this. You could put in there that no bandmate can spend money on equipment if it's over a certain amount of money. So nobody will be buying a brand new set of drums unless the partners in the band agree to that, because otherwise they may be taking it out of the pot. So see how it can become not just a liability thing and a conversation piece, it can actually guide you procedurally in moving forward the rules. So you're going to look at what sort of business do you want to run as a band? And I also have this conversation with people. I was just talking to my boyfriend about this, about, Katy Perry, Rihanna, Kings of Leon. Literally, I mean, I can name anybody, Foo Fighters, Rolling Stones. Like, they are business people. So yes, they're musicians. Katy Perry's a businesswoman. So I don't care what you do, how talented you are, how you want to be in the music field. Like, you can be you could be like Lana Del Rey, you could be like Britney Spears. It doesn't matter. They are all business people. And so there's a business component to the music industry. So that's what I'm asking for you to think about, is not to change who you are, not to change your music, not to change the image of your band, but to recognize the underlying, this needs to have a formal entity structure, formal contracts, and I have to ask the question, I have to do the reality testing with the people involved. Are you as serious as I am? And if you're not as serious as I am, I'm sorry, you can't be in the band. Next one, Nicole. So agreement with bars. So unfortunately, the slide's in here because the hope for all of us, I mean, I wish I was right now talking to you at a bar, drinking my third or fourth beer or cider, and listening to live music. Like, I'm right there with you. I don't know how you feel, because we can't begin to imagine what other people feel. It's all different during this pandemic, but things will open up again. We will be live again. So I want you to think about the agreement that you have with the bar. I have too many clients and friends who are, oh, well, this bar told me that if I make this amount of money or bring this amount of people in, they're going to pay me, or they're going to give me a percentage of door fees, or like they try to explain to me what that is, but it quickly falls apart. Not because that's not going to happen, but what if I told you, I don't want that for you. I want you to have with the bar, even if it's 2 pages, a contract. I want it to be legally enforceable. So if someone's going to pay you a certain way or give you a certain percentage of door fees, we want to have that there. What if you were supposed to perform at the bar and you forewent another opportunity, and then the bar owner says, oh, well, I can't have you, whatever, something didn't work out. Well, I just gave up my other thing that was going to make me money to come and perform at your bar. So what if I told you that in that contract, we could say that, if they cancel last minute, they still have to pay you some sort of fee, or they still have to, you know what I mean? So these are things, and same thing, it's a test. If the bar does not want to do this, you have to draw a line and say, sorry, I'm at the stage in my music career where I have to demand to have these contracts signed. And it's not a 25-page agreement, it's a couple pages, it's going to protect us both. Because if you think about it, it protects them, right? Because they have guaranteed live music. So it's not just about you getting money from them. It's, you can pitch it as, you now know that I'm contractually obligated to perform at your bar, which is going to bring in people that are going to buy food and buy drinks for you. Next one. An artist agreement. So, this could be a performer agreement, an artist agreement. People often call this rider. Usually the rider is the attachment to the artist agreement. There's all the famous riders about like Van Halen not wanting brown M&Ms and, people being really picky. We hear all these stories about celebrities that are like, they have to have like, I don't know, carrots from a special country, or they have to have a certain kind of water, or so yes, that can be part of your artist agreement. Not yet. I mean, you can say that you, for food, want an all vegan diet. That's fine. You want vegan food. That's fine. Don't go crazy with this. But the question is there's always this question with our clients of, am I there yet? So am I deserving? It's this imposter syndrome thing, and especially creatives have it. I am not a celebrity yet, or I'm not a musician yet of that caliber, and I don't think that I can have my own agreement, and I don't think I can have my own qualifications. You can be humble and vulnerable and authentic, but also demand the things that you deserve at the same time. It's possible. So I want you to start thinking about this. So when you have an artist agreement, going through that process with you or your band, even if you don't use your agreement, you use theirs, you use a tour agreement or something else. Because we've gone through that process, we know exactly what you need. We can reconcile the terms. So let me give you an example of some of the things that could go in here. So what if you have to have a particular type of speaker quality? Because you know that your band, if it's not the right speaker, it comes off shitty. People are filming it, putting it on YouTube. People think that that's the quality of your music. What if I told the people where, anytime I perform, I have to have this speaker quality, or we have to have 4 microphones at least, not 1, not 2, we have to have 4 or more. Can you change these things? Sure, we can waive them. We can work with people to make sure that for that venue, things might be different. What do you need? Do you need space for your lead singer to dance, to jump off the stage like Florence does in Florence and the Machine and run around? Do you need these certain requirements? So it's not just food, it's not just water, it's what do we need, right? Then there's this very big intellectual property component of this. So are people at the venue going to be from the venue filming it? Will they be putting it on their venue website making money? Will people who are guests be able to film it? Are they going to be streaming it? Where does that go? Is the venue filming this and then making money off of it? Can the venue sell merch that's not our merch? They know that we're going to be performing a show. They create their own merch. They profit from it. So, I mean, these are the things that we have to think about. And I don't care, like, believe that you are who you are and that you're special, not in a horrible way, not in a diva sort of way, but demand more, and that's what you'll get. Like, you have the right to do this. So that's what the artist agreement is about. So I keep rambling, but we can go forward. Recording contracts. So it used to be that you would only get a recording contract if you were a certain person, you know, like they didn't give them out to everybody. So it's not that they give them out to everybody, but in a way they do right now, because they realized that it's sort of like years ago, it was you would get a recording contract, they would put everything into that person to make sure the recording contract succeeded. Now they give everybody a recording contract, they half-ass how they help you and manage you, and then whoever rises above is who gets invested in. So there's a different process for that. But one of the things that I want you to be aware of is these 360 deals. I actually had to help a couple clients get out of them. Not a fun thing to do. So a 360 deal is where the recording, the record company, they grab at all that you do. So that's a 360. So if I have a recording contract with you and you're not making money off of my music, if I am modeling, if I am doing graphic design, if I'm selling merchandise, per the agreement, you're basically reaping profits from those other things that I'm doing that are not necessarily music. So that's how record companies right now are making money, is they're taking money from an artist from things that are not music related. Because in that contract, in that 360 deal, it was contracted for. So do not get into a situation like that. Be aware of a multi-album deal. That's another one. So these happen a lot. You're stuck there for 5 CDs. That's horrible. How do I know if I'm working with you that I'm going to want to work with you again? How do I know I want to work with you for a duration? I'm sure you hear it. We've heard it, all the celebrities, about how they're stuck in the CD deal or stuck. Okay, whether, you know, however big you are, what if you're at the height of your career where you're about to be really big and you hate the company that's the record company, you can't get out of it, you have 4 more CDs to do with them based on your agreement. What do we do? Like, you now have to work with the same shitty company that's not marketing you well or that's not believing in your style of music. So do not ever agree to a multi-album deal. If you have to, maybe 2. But also in that contract, we're going to add, you know, stipulations about creative freedom, about style, about album art, and then maybe we can agree to an additional album because we have those creative freedoms that are embedded into the contract. Be aware of the company's promotional budget and actions. People always say that they're going to have a manager just for you and then they're going to promote you. There are reputable companies that really do care, and they really will. So asking specifics, okay, well, what does that mean that I'm going to have a manager? What does that mean that I'm going to have someone do promotions for me? Are you emailing people like in a spammy way, or are you actually contacting venues that you have relationships with? Are you adding me to a show with someone else who's up and coming? Like, we need more specifics to this if we're going to work with this company. Be aware of who owns your IP and who has the right to license it. So if you are writing songs while you're under a recording contract, do you own them or does the record company? So when you're done with the record company, do you lose your songs? Do they hold the rights to them? Happens to a lot of people. And it's been going on and on. It happened to Etta James. Etta James didn't own her own songs. And a lot of people don't own their own music, or they own a very, very small part of it. So asking yourself, what kind of ownership do I want over my own IP that I am worried about the record company owning, but I'm also worried about what they're going to do with it. Because what if they take the songs that I wrote, they drop me from their label, and then they use those songs for another artist that comes along? I put on the radio, I hear an artist who's singing the song that I wrote while I was at that record label. Well, contractually, that might be fine because I didn't pay attention, or that's what I was contracting for. So be very careful with reporting contracts. We have a lot of clients who they're excited about things, right? Like not just for music. We have clients who have gotten publishing deals. I have a client right now who has a deal for Spotify and for Target, and it's like, oh my God, oh shit, like I'm gonna sign this. I don't care if they're Nike, Target, Columbia Records, whatever. You have every right to ask questions and to negotiate and to ask for more details and to ask for more descriptions. You have that right to do that. So don't think it's either take it or leave it. This is another good test. If the record company doesn't like you asking questions or says it's a take it or leave it, that's not a company that you want to work for. So granted, it would be great to have that record deal, but there will be another record deal with a company who supports you. One of the famous stories that I really love is the Alicia Keys story about Alicia Keys had a contract with Columbia Records, and they told her, they said, okay, you have to take out your braids. We don't want you playing the piano. We want someone else to play the piano or play another instrument. They wanted all these different things for Alicia to be either, I don't know, more white or whatever they wanted from her. Like, be more jazzy, be this, be that. And she's like, no, like, screw you all, right? So I don't know what company she went to, but she ended up winning 6 Grammys after that. And she turned down Columbia Records. So someone probably at the time was like, Alicia, you're crazy. You have a deal with Columbia Records. But she said, if I were to go with Columbia Records, I would have to rid myself of every single thing that I was about, both as a person and musically. So if you ever feel like you're doing that, excuse my French, but, fuck that record company. You take your success as an artist and you pitch it to another record company, and you find a record company that's one that actually cares about you and cares about your art, and is okay with you touching on these things. No, I'm not going to do 5 CDs. No, you're not going to take my money from other things that I'm doing besides music. Okay, next one. Licensing agreement. So we have a lot of clients who ask about this, how, and this is for music and everything, especially in this virtual world. We have clients who do business coaching, and they're putting on a seminar. I have a client who they're doing a queer competency certificate where they're training people about gender equality. And so it's this whole certificate program where, there's materials and there's audio. And so the question is, well, what is your intellectual property and what do you own and how is it getting out there? So if you know where it is and you know who has it, you can be very successful in doing licensing. So you can be someone who gets their song, on like a Love, Simon movie or something like that, which I love the soundtrack for that. So you can be an artist who finds ways to get placed into movies and commercials and things like that. You can also make a part of something. Like you could be someone who makes beats or tracks that get used by other artists. They get licensed to other artists. So a pop star will go into this sort of search for tracks that they can use. So the point of this is you need to realize what you're creating, what kind of IP you have, how it's protected, how it can be protected, and then you need to figure out, how am I granting permissions outward for this? And what is the worth of it? So Nicole talked about copyrights. Nobody's going to pay you to license your song if you don't have the federal protection for it. The reason is because why would I pay you if I know that other people can copy you and we can't stop them? So I'm very likely, or anybody, a studio, whoever, would be very likely to invest in or to pay someone for licensing who has their shit together, right? So I find out you as an artist, you have a business entity, you have a trademark name for your band or for your company, you have copyrights for your songs. I go, wow, this person's serious. Not only are they serious, but if we had to stop another person who's not privy to this licensing agreement from using this song, I know that you and I could go to court to stop them. If I license with someone who doesn't have those things together, we're not going to be able to do anything about it. So if you're someone who wants to do licensing and you think about that, I encourage you to think about prior to that. So not even just the licensing agreement, prior to that, think about how you can protect your IP so that when you actually do the licensing, the person you're licensing to, they go, wow, this is someone who really has, they have a whole portfolio of protected tracks. We're ready to do business with you. Okay, next slide. Client service agreement. So everyone has a client service agreement. This is one of our bread and butter services for everybody, because if you think about it, like even a restaurant, when you order food at a restaurant, the menu is the offer, it's the terms. You order something, you eat, you pay. That was a client service agreement. Everything we do is some sort of client service agreement. I'm going to perform, you're going to pay me. I'm going to do the service, you're going to pay me. So the question is for you is, do you have that? So whether you're a DJ or a karaoke host, or you're an artist who is going to different bars, do you have something that you can give, even if they have their own agreement? Remember I said you can use it to reconcile their agreement and say, hey, I'll sign your agreement, but you're missing 4 things that I usually like to have. Do you have some sort of contract that is going to exemplify your processes? And can you give that out to the person who is contracting with you? If the answer is no, you might want to think about that. So what if I told you that if you just had a couple pages of the document, and every time you perform somewhere, you give it to the venue, and the venue would sign it. And then you know that you're going to get paid net 15, because that's what it says on the contract. You know that they've told you that you're the exclusive performer for that night. They're not going to have anybody else. See how with just that document or that personalized client service agreement, we're protecting ourselves. We're setting forth, these are our rules. This is how you hire me. This is how you pay me. So it's really important to think about that, what that looks like for you. It could be different for anybody. Okay, next slide. So we are on Q&A. That's a lot of topics in a short period of time. The best way to always discuss these things is through questions. So I'm sure Nicole also is open to questions that you have on either of our presentations about something else. We're happy to answer it.
All right, I think Austin, are you going to be going through the questions and asking them?
Yeah, sorry, my internet just actually gave out for a second. Thank you, Michael. That was wonderful. It looks like we have quite a few questions here. Michael, you and Nicole both can kind of take your stab at the questions as they come up.
I didn't get that. Could you?
We'll start from the top. We have a question from Maliki Graham. Does Rational Unicorn offer a templated split agreement form?
We have, we don't have it on our website, but we have that. So if you email us, we can get that to you. And that's usually not something that our firm charges for. We'll just give you split sheet templates.
That's great. Thank you. Next question, can band members be work for hire? Sounds like they can, but I'll let you answer that.
Yeah, so that's a really good question. Let me think of how to like unpack that, because so a band member could be work for hire, but if they're going to be getting future royalties, they're not work for hire, because the work for hire implies that the relationship is over, that they perform. So let me phrase this a little bit differently. So, everyone's an employee or a contractor. A contractor, you can have a contractor, like a contract band member for forever. Someone could be a contract bassist, contract opera singer, whatever. Work for hire implies that if I hire them, I keep everything they did, that they have no ownership. So the question comes down to is, do you want that person to maintain ownership? A contractor by default maintains ownership. An employee by default does not, the employer does. So a work for hire contractor is someone who, instead of like other contractors would maintain ownership, the person hiring them does. So the band or the lead singer. So the question is more so, does the person that's a bandmate, that's a contractor, do you want them to own anything they do or not own anything they do? And that sort of relates, that would sort of give you more of an indicator. If what their involvement is never going to be them owning anything, then sure, they're a contractor with like a work for hire sort of thing. If they're a contractor that's going to have future ownership of some type, they're not a work for hire, because they're giving ownership to the band. We can talk more about that. A lot of those questions are situational, where we have to look at, okay, what are we trying to do here? How does this all play out?
Got it. The next question comes from Monchris Hubbard. You use the term contractor agreement. Can you clarify that you are using the term to refer to contracts that may be with employees, not just contractors? Kind of relates to the last question a little bit, actually.
Yeah, so most bands don't have employees. Like you have your band, which is everybody's like an owner. So in a band, partners would be owners, or the bandmates would be owners. You wouldn't necessarily have employees unless you hired someone. You reach that point where, you have a full-time assistant, or you have whoever. Most bands hire contractors. So the contractors that I'm talking about are, if you're hiring someone to mix something, or you're hiring, a bassist to play on a track, I'm talking about people who, they don't. So I'm trying to think of how to unpack this as well. So if you were hiring an employee, that would be someone who they would have duration. Hiring a contractor is for like a set project. They do this project and that's it. An employee, there's what's called vicarious liability. The employer is liable for the person. A contractor, you're not liable for them. They're liable for themselves. So I think the distinction is more so, are you hiring an employee or a contractor? Do you need someone who you can closely supervise that's going to be there forever? Not forever, but for duration. Okay, maybe they're a part-time employee. Or are you hiring someone for one gig or one track, or for a shortened duration? That might be a contractor instead. The other difference is that the contractor, they pay their own taxes. When you hire an employee, you have to do payroll, and you have to pay them taxes through a payroll system. Hopefully that answers to some degree.
Yeah, I think that's great. The next one is a beefy question. I've heard Portland's music economy is underreported because companies do not select music-related NAICS codes when setting up their business. NAICS classifications are not up to date with music business and technology. My microphone company, Ear Trumpet Labs, operates under the NAICS code for testing laboratory. How can a company, LLC/band, or other new entity make sure that they start with a proper NAICS code?
Yeah, so to be honest, those codes, like, they're made out to be more important than they are. I mean, I know it's horrible to say, but nobody knows which code to pick. Nobody knows, like, even under the art category, there's like art lessons, arts and humanity, music instruction. Like the list is so long. There's a humanities section. So I don't necessarily think that code, I don't think that it's extremely important. If you get the wrong code, if it's somehow related to what you're doing, that's fine. As far as like income being underreported, I think with any sort of art world, that's just the reality. I think that the IRS knows that.
Well, I'll chip in, Michael, because I know Malachi's heard this from me. We did assessment. The NAICS codes for shoelaces are like many hundreds of different options. For music, it is a tiny, it's maybe 30 different options, and more than a third of them are for printed sheet music. It's like they stopped actually evolving the options. So companies look at it and go, well, no, I'm not a gramophone company. I'm going to go over here and be in electronics. And the downside to that is when you're trying to actually quantify an industry, the only time it matters, the only times those codes matter at all, is when you're trying to have the city say, well, we're going to go and look and see how much economic impact you have. And it's absolutely vacant. We did a check of it, and more than 60% of 200 companies in Portland that are well-respected music brands were not listed under any sort of music referencing NAICS code. So that's the reason. And yeah, just as you're setting up a business, just wondering.
So from an economic perspective,
yeah,
on evaluating, I see what you're saying. You're saying that the city doesn't understand how big of an economy in music that there is because things are misclassified.
Yeah.
So I don't have the answers to that. I mean, that's something that I'm a big fan of telling the government what they need to do. Like you just have to keep fighting for that change. And if that's something that needs to be reconfigured, then let them know and let them know why. I'm happy to sign off on a letter for that if one of you writes it. And not that I'm, all powerful, but I try to support things like that when I can, if they make sense. I'm for sensical things.
Yes.
And logistical changes that like work for, we're trying to right now. The pandemic's kind of put a burden on it, but among all the things that I do, my boyfriend will kill me if I take on an additional thing, but we're trying to make benefit company certification records better, because people who are certified benefit companies, nobody knows if they've been recertified. Nobody knows if they just checked a box because they thought they wanted to give their employees benefits. It doesn't say when they were certified. It doesn't say what they do. So like, there's a list of certified benefit companies through the Secretary of State. There's no sort of information as to who they are and what they do and if they've actually been certified. So my point in that is that there's numerous things like this that it would be really easy to just make these changes. Like I think they're like simple logistical bureaucratic changes, like have a meeting, we have meetings every day, and figure out how to change that process. So yeah, I think just, keep fighting for that if that's what's needed, and hopefully somebody will listen.
Excellent. We can talk offline. Sorry to jump in. There are more questions.
All right, Michael. The next one comes from Julie. It's actually a couple questions, but she's looking for some clarification in terms of terminology when it comes to contracts. So She's curious about the difference between the term songwriter and composer and the difference between producer and publisher. Are you able to clarify that, or is that getting a little too in the weeds of music lingo?
Yeah, I mean, I can try. The hard part about this is like, it's a semantical world we live in, right? Like everyone will tell you that they're one thing, and then are they really that? So it's not like the composer publisher distinction would imply that the composer is the one making it, actually composing. The publisher would be the person who is publishing that. Their act is not the composing, it's the publishing. And so the problem with trying to figure these out is that the worlds collide. People label themselves as one thing, but they're really the other. Sometimes people do both. I think it's sort of like that expression, like the devil's in the details, right? So don't go with what someone's calling themselves, go with what the terms are that are listed below in the contract, and be sure that that's exactly what's needed. Nicole, do you have a thought on that? Like semantics and contracts or labeling of people?
Just like you said, Michael, it depends on each contract, I believe, and it depends on what they're denominating on that contract to be. So make sure you read through and it makes sense to you.
Yeah. And again, that's the same test I keep bringing up. Like, if you ask the person, can you be called this other thing? Because I think that you should. And they say no, and say, okay, well, I have a problem with this. Or in order for me to be comfortable with you being listed as composer, I need for you to accept these terms into the contract. Okay, well, they don't want to do that, then we have a problem. So it's always sort of, don't let things that stop you in your tracks, like don't just be submissive to them. Actually tell the person, like, I have a problem with this. I don't think this is how this should be defined. Or can we add these things to this? Hopefully that. Some of these questions are hard because it's like without actually looking at, the agreement or knowing more about the situation, it's really hard to speculate on it. But what other questions are there?
Yeah, there are some specifics in here. The next one comes from Tyler Stone. What are the advantages or disadvantages of setting up an LLC in Delaware as opposed to Oregon? Delaware.
Nicole, do you want to talk about that, or
I mean, in general, I can speak to Oregon. Building an LLC is pretty easy and quick comparing to other states like New York, where they have a publishing requirement for 3 months and you need to pay for that. So higher cost, a bigger amount of time. I don't know specifically about Delaware. I know they have taxes, benefits, but I can't speak to Delaware specifically.
Yeah, so Nicole's right about the complexity of the LLC process. So LLCs are filed at the state level through the Secretary of State's office, or sometimes there's like a separate corporate division that a state will have. Like California is kind of like that. They have like a corporate government entity or agency. The thing you need to know is that the Delaware thing is kind of a myth. And it's kind of, it's corporation specific, right? Because it has to do with shareholders and equity and tax breaks for corporations. An LLC is seen, it's filed at the state level. An LLC is seen by the federal government as a pass-through entity, as if you were like a sole proprietor. The federal government, they recognize an LLC as a business, but they don't see it as like a corporation. So unless you're forming a corporation and the question is, okay, California or Delaware, then there might be different corporate tax breaks or tax structures. The other thing to think about is most places you form a business, they want you to have some sort of tie to that state. So they want you to have, a principal place of business that's in that state. So like, if you have no tie to Delaware, other than, wanting to file there, the state is probably not going to let you file there. The reason why like large corporations can is because they either decide to move there and operate there, or they open an office in Delaware. So that, see how, like, if you're in Oregon or California or Washington and you file in Delaware, we can't prove that there's any sort of involvement or relationship to Delaware. So it's just not worth doing that. So yeah, that's sort of like an old, not a wise tale, but everyone's like, oh yeah, file in Delaware. But yeah, it's really only if you're a corporation and you have a tie to Delaware and there's a reason why you're doing it. Like, you have to know that that particular Delaware corporate law affects something that you're doing business-wise. It's going to give you that either tax break or deduction.
All right, we just have time for a couple more. The next one comes from Achilles Montez. Should band leaders have a dress code, code of conduct agreement?
Nicole, do you want to go?
I feel like this is free interpretation a little bit, but
You can, yeah. The answer is it's up to you. You know, you can have, I mean, that's honestly up to you. And that's why having like a band partnership agreement is great, because you could have the band partnership agreement. You could put in there a code of conduct, or what you could do is you could have the band partnership agreement, which is about like profits and losses and partners. And then you could cite or integrate the code of conduct. So you would say, like, in addition to this band partnership agreement, you know, all members will sign this code of conduct. Is it legal to do that? Sure, absolutely. You're in a band and you have a particular kind of branding or a particular kind of look. I mean, that's exactly how do you think like B2K is B2K, or I'm trying to think of other, like, there's got to be something in the contract between the members to do those things, to wear that thing or to have that style. I presume, I mean, I don't know why I just thought of like No Doubt, like a 90s No Doubt. I presume there's something about like they had to have that like ska feel, and not just their music, but their outfits. You know, you don't see like a No Doubt person in goth or like some other. So I guess the answer to you is yes, you can. And I would encourage rules like that on what is the style. I would never say that someone must wear a certain kind of jeans, or, you know, they have to have like, everyone has to have Louis Vuitton or whatever. Like, it has got to be, it could be specific, but it's got to be very like, you can do this however you do this. So as long as you wear a black polo, you pick whatever polo you want.
All right, guys, I think that is all the time we have for questions right now. I want to thank you both for being here tonight. Yeah, I think it was very insightful and a lot of great engagement. So happy for everyone who is here and for you guys for leading this.
Yeah, thank you for having us. You know, Nicole and I are always available if someone wants to contact us. I think actually on this slide, if you go to our website and then dash contact, we offer a 30-minute no-cost consult. So we could talk to you about what your questions are, kind of like this, and then give you service options. So basically say like, well, it sounds like you should put that in a band partnership agreement, or it sounds like maybe you're ready to form an LLC. Here's what that would look like. So kind of guiding you into whatever your next step is. We're happy to do that.
That's amazing. All right, well, thank you everyone for being here, and have a great night.
Yeah,
Thank you, everyone.
Thank you so much.
you.
Bye now.